Thank you, counsel. Justice Thomas, anything further?
Would you take a minute and walk me through why you think, or why it's agreed here that subsection 2 regulates safety in intrastate cases?
So, the argument would be that, you know, if this were a B case, and I was trying to argue that safety is not preempted, what I would do is I would make an argument sort of like I would make in the airline deregulation context, which is to say there were these tort claims beforehand. They probably, like, the last thing anybody would have thought was going to be preempted beforehand was an intrastate tort claim. And all Congress was trying to do with B is to make sure when they deregulate interstate that there aren't these sort of confusing intrastate regulations of the same economic things. So that would basically be my argument. I could warm to it and try to get a little more textual and try to say that, you know, it's written a little bit differently, and it really does focus on intrastate rates, interstate routes, interstate services of any freight forwarder or broker. And it's just a little hard to think of these, like, negligent hiring things as being sort of like distinctly intrastate. But it's a harder case than C. I'll grant you that.
Was there ever any federal involvement during the ICC era with intrastate shipping?
No, that was, I mean, except in one or two areas where they felt like they had to do it to rationally regulate interstate. But under the old ICC, the basic division of labor was interstate federal, intrastate state.
So why would this have any application at all, just structurally, to intrastate shipping? If the deregulatory effort is to deregulate covered areas, and this area was not intrastate, why would it have any application at all?
Oh, I'm surmising now, but I think the idea was, okay, like in a world where everything's regulated at the federal level, it's pretty easy to sort of hand off like regulation to the states when it's intrastate. But in a world where you really want the free markets to sort of prevail, having this little island of state economic regulation of intrastate starts to seem like less wholesome, and it's sort of interfering with the federal objectives. And in this regard, it's probably worth recognizing, you know, the federal deregulation takes place in 1980. They don't impose the preemption provision generally until 94, and then they don't address brokers and freight forwarders till 1995. So for 15 years, the federal government was perfectly happy to deregulate at the federal level and let the states kind of do what they want. And then at a certain point, I'm surmising that they said some of the state regulation is getting in the way of our federal economic deregulatory objectives. But at the same time, you know, the one place, well, in the two places, because they did it for passenger too, they really did try to preserve state regulatory authority with respect to safety in motor vehicles.